when you get injured on the job, you run into a nightmare of workers' compensation. Let us start with this claim. This is how the insurance company will try to take advantage of you if they know that you have no lawyer. They know that you don't know what the law is, you don't know your rights, so they will try to do everything to scam you, to take advantage of you, to frustrate you. So let us start with this complaint of workers' compensation. I redacted some names just for personal reasons and to avoid any kind of interference with the process. Well, here is that email to me regarding the claim. It is to me, good morning, Mr. So-and-so. It's a mileage reimbursement will be paid for medical appointments completed pertaining to the injury. You will need to submit in writing of the dates that you completed appointments and the mileage to leave that. Now you can elect to receive either one check to totaling all mileage completed at the end, assuming that if you already are a worker compensation. Why do you have to wait for the end? They are stupid. They think that you have too much money. You can wait until the end of your treatment and you have one check. Or submit mileage to me after each appointment is completed. This is the beginning of the frustration. Let us see how the process will work. Regarding lost wages, here is the scam. Here is the beginning of the scam. Regarding lost wages, as we stated in the interview, the lost wages were not owed to you. What a scam, what a foolish argument that the lost wages are not owed to you as medical documentation. Here is she is going to play it again as medical documentation was received after your termination with Walmart. So you have an injury at Walmart and then you are terminated and then you reported the injury. They tell you, oh sorry, we can treat you, we can take care of your medical care, but we are not going to pay you lost wages. Well, this is not the law. The law doesn't state that. But let us find out, because when you don't know the law, you cannot argue with these people. That you were placed on modified duty. If you were still employed or when your treatment was completed and placed on modified duty, then lost wages would be owed. So the trick she is trying to play, she said, because we received the documentation after you were terminated from Walmart. That's why they do not want to pay me the lost wages. Look at what's going to happen after that. I understand that you currently have an investigation ongoing regarding the termination. That is called an OSHA investigation. Unfortunately, I don't have authorization to interfere or proceed with paying lost wages. So she does not want to pay lost wages. I received the notification that you are scheduled to complete an MRI of your left hand and right hand on February 7th. I have provided all billing information to the company so that you are not, she is going to take care of the medical bills, but she does not want to pay the lost wages. So you are not billed for these services. If there is any issue that arises or concern, please feel free to provide my information to the provider. And here is the case manager, her phone number, her email, and you have, of course, when you work with Walmart, like any corrupt company, they have a lot of respect, a lot of the service, excellence, integrity. Of course, I sued the company for they have no integrity, they have no excellence, they have no lousy service, and no respect for the human life or the human beings. Here is my reply. When I heard that, I forgot what I told here before, but let us hear my reply. Per our discussion and your statement that Walmart claims do not owe me wage losses. And after reviewing the law cases of Utah laws on work-related injury, I determined that 1. My injury originated at work 2 years and 4 months as a cumulative trauma on top of multiple accidents with specified dates and times. That is number 1. Number 2. My work-related injury resulted in restricting my ability to work and the loss of wages. You administered the timely medical services up to this date but declined to compensate me for lost wages. This might make more sense. Based on your assumption that I was terminated from employment before the diagnosis. Since the diagnosis and treatment of unpredictable work injuries cannot be predicted before termination from employment before the diagnosis, therefore you owe me lost wages and all interest that resulted from your refusal to pay my lost wages in a timely fashion. If you still insist on your previous decision not to compensate me for lost wages, that I will follow the proper grievance course for defending my right for compensation for lost wages. I said thank you, yes. The adjuster responded to me. That is her email, and that is to me, and here is something with my name. There isn't a flaw in my logic, and it is unfortunate that you feel that way. Here is the first confrontation with me and her. That is the adjuster. Her logic was flawed, and she feel unfortunate that I feel that way. Worker compensation is. Let us see how she is going to explain her flawed logic. Regulated by the state of Utah, I am obligated to follow the guidelines of the state. Did she follow the guidelines? No, she did not. Wages are not owed to you. I informed you of this in the initial interview. If you were still employed and completed, how is she going to get out of that? And completed treatment prior to the termination, then lost wages would. So suppose she is just stupid. A lot of people in this level of jobs are stupid. She doesn't know. Then lost wages would be owed to you. The time delay has nothing. The time delay of what? The time delay of reporting has nothing to do with completing medical treatment prior to termination. It would not have mattered if you were terminated or not. Lost wages would still be owed to you. If you were employed and completed treatment prior to your termination, look, how do you complete the treatment prior to your termination if the treatment cannot be completed? The treatment will take forever. It would not have mattered if you were terminated or not. Lost wages would still be owed to you. This did not occur and you sought medical treatment after you were terminated, which placed you in modified duty capacity. Another way, she is thinking from her head. She is not following guidelines. She said if you completed treatment, medical treatment, prior to termination, when you cannot complete medical treatment prior to termination, then you would have been put on modified capacity, and that at that time you would have got your lost wages. Your injury is still compensable. Injury. And the medical treatment is being paid for the treatment that you are completing at this time. Please understand that workers' compensation and OSHA are two separate entities. Your medical treatment is very early on. That we do not know at this time if this will be a lifelong disability. However, we will do everything possible to ensure you receive the medical treatment you need. Well, she changed her tone now. Let us see. I am more than happy to discuss this with you. If you would like for me to call you, or she wants to call me to tell me we don't owe you medical treatment because you did not complete your treatment before you were. How are you going to discuss that with me? And answer any questions you may have. Thank God. Thank you for answering, for being so respectable and wanted to cheat me. Now, I forgot what date was that. Reporting the development of painful, the other hand failed, the left hand. To me, I have submitted the information regarding your additional injured body part. That That is the left hand now. To nurse case managers to review. The nurse has requested the medical notes and MRI report to review with the medical director. That was in February 9th. Once I have an update, I will inform you of my new information. Now she's going to play a trick now. We got over that first problem or first trick or first gimmicks that she does not want to pay me the lost wages because I was terminated before I reported the injury or before I completed treatment. I inquired about lost wages. Good for you. Good for you. Now she came up with something different. I inquired about your lost wages being owed to you. During this inquiry, lost wages are confirmed to be owed to you. Okay, so we got over that now. From the date which you sought medical treatment, which is January 1922, lost wages are paid at a maximum of $1,038 per week. That is about 60%, 65% of my regular weekly pay. And will be placed on bi-weekly amount of $2,000. Every 2 weeks you get $2,076. Now we changed it. This can be received via electronic fund transfer setup and or check mailed to the address we have on file. Your banking information would need to be provided on the form authorizing setup for the electronic fund transfer and a photo of the voided check. That she gave me a trouble with that voided check. Nobody uses check these days. That transcribes your name and banking information as well. Let me know if as soon as possible how would you like to proceed. If you have any question or concern, feel free to contact me. Here is the best regards, the case manager. That woman suffered a lot from my constant onslaught. She gave me a hard time. Okay, here is the claim and ended up by respect, service, excellence, and integrity. Now, unfortunately, now she came up with another fantastic, stupid thing. After what? After almost 2 weeks. She does not want me to get paid. Unfortunately, I am unable to submit these to accounting without, this was about electronic funds, without the information requested, a bank statement or correspondence that shows the requested information would be helpful as well. Fine, she wants a bank statement. Now, here's the new bad news. She's going to play another stupid game. Please find attached a peer review. Well, pay attention to this scam. Completed regarding the injury that you sustained. The peer review, nobody asked for a peer review. You don't, the hand surgeon asked for independent medical examiner. She wants a peer review. She is going to scam me for the second time, and somebody else scammed her, or she, let us see what happened. As you know, an MRI was completed that shows degenerative changes. I know that. She did not say what else in the MRI. In both wrists as well as the determination from the specialist, Dr. Ramesh, stating that, well, she's going now to take the statement of Dr. Ramesh, which is a hand surgeon, out of context. He requested an independent medical examiner. He said it was acute on chronic. He said something about, he used some fantastic word, the symptoms are not causality. Well, anyway, she said the MRI of both wrists and the doctor determination. He did not make a determination. He asked for an independent medical examiner. She is going to take that out of context to give me the bad news, stating that Dr. Ramesh, the current injury is not necessarily created by any change in the natural history. Dr. Ramesh said natural history of the arthritis. Well, if you drive a truck, you are not a natural person. You cannot have a natural history. Well, he put the word natural history for everybody to interpret it in any ways you want. Natural history of the underlying chronic non-industrial issue. How did Dr. Ramesh knew that it was non-industrial, it was chronic? Well, if you work chronic, yes, but if you're working chronically, you're working for so many years in this job, are you saying that the degenerative changes are natural in that age? They are natural, but is the driving of a truck is a natural thing? And if it is chronic and you work for a long time, which means you are a chronic worker, how did he say it is not non-industrial? But look what happened after that. So he said there is a chronic condition that is non-industrial, so he qualified it as not related to the job because he wants to get out of any trouble. And he said that natural history, what is the history of a chronic condition? Natural history in an unnatural person, working in an unnatural job. Here, the peer review completed also determines also. So she wants you to think that you have now two doctors, Dr. Ramesh, and the peer review completed determines also that you have been placed at a maximum medical improvement. You have been placed at a maximum medical. Now I'm maximally improved medically. That is a stupid peer review determines that. We're going to find that in a minute. So I'm improved. How did I know? I didn't. How comes I didn't know that? How comes I didn't know that? The medical review determines that I am completely improved. So I need to get the hell out of there and go away. But I didn't know that about myself. And no further medical treatment would be industrially related to the injury, which simply means we don't need any more medical treatment, and it is not related to the industry, and your injury just suck it and go away. It is not our problem. Would be industrially related to the injury sustained based on two separate medical opinions. So if you have two opinions, the hand surgeon, which is Dr. Ramesh, and the peer review, which is another thug. We are going to have his name in a minute. Two separate opinions. No further medical treatment would be appropriate and or compensable under the workers' compensation claim. She made the determination that stupid, I do not want to say stupid adjuster, somebody is pushing her. Somebody is trying to, tighten the scam. It is not, you don't need any medical treatment. You are fully, maximally improved, and it has nothing to do with the industry, and get the hell out of here. The only other option, we still have another option. Good. Only other option available. As a matter of fact, that was the only option that was available in the beginning, would be to complete an independent medical exam. That's what the Dr. Ramesh said. You need independent medical exam. How do you know that the examiner is going to be independent? You do that in the court. How do you know that he is medical? You do that in the court. How do you know he is going to do the exam? You do that in the court. However, that's scumbag. However, I cannot promise that. You see, because she knows that I have no lawyer, she thinks that I'm waiting for her to promise or to keep her promise. Or she's going to walk on my dead body if the only thing here is her promise. I cannot promise that a differing opinion will be rendered by that physician, that is the independent medical examiner. She wanted to tell me that she cannot promise that the independent medical examiner will render a different opinion. She seemed like to know the independent medical examiner. He's not going to say different opinion. That's when you get scammed when you don't have a lawyer. Please let me know how would you like to proceed. No, I like to proceed by letting you scamming me. That's what I like to proceed, you idiot. As well as Cheryl, this is a nurse that got her in trouble. That is a nurse. Cheryl, instead of seeking independent medical exam, she tried to help Walmart. So she went to one of the fraud doctors with enormous title, doctors, PhD, MD, professor, and she wanted him to give her an opinion that can help Walmart to evade like a medical excuse. As well as Cheryl is available to answer any question from a medical perspective that you have regarding the peer review. Yeah, I answered that question to her after that, to both Cheryl and the case manager, and I screamed and yelled at Cheryl for trying to cheat me. And as usual, you have the respect, service, and excellence and integrity. Now, where is my reply? That was in February 24th, outstanding therapy. Dear Miss, I need to know for fact if you meant to terminate my weekly pay of lost wages. If she can do that, that would be stupid. This is an urgent matter since I withdrew my unemployment insurance benefits after receiving work comp, because you cannot have both. You cannot have unemployment and work comp. So after I withdrew my unemployment insurance and received one work comp, if she cut it now, I'd be in trouble. I wanted to know for sure. My lawyer is in the process of seeking hearing with the Utah Labor Department to present my case to work comp judge with all relevant facts. The peer review, this is, of course, now she knows I am going to have a lawyer, and she knows that the case has to be determined by a judge. The peer review by Dr. David Ring. Dr. David Ring is a disaster doctor. He is a fraudulent profession. He's committing a crime. He should be reported to the authorities for trying to defraud the insurance company by giving them the wrong opinion. Not the wrong, he is deliberately misleading them. The peer review by Dr. Ring cannot stand any legal challenge because Dr. Ring injected his subjective views, made unsubstantiated claims and speculations. He speculated that the injury was there for decades before. Well, he has no proof to that. He made unsubstantiated claim that I'm outstanding person and I should be, and nobody else can do what I do. Then he made subjective views that cumulative trauma is not a real thing. He does not believe in them. A very bizarre individual. Well, he wants to make money, so he can say anything. You pay him money, he can commit a crime. He does not, here is my points. He does not believe in cumulative trauma. If he does not believe in cumulative trauma, that means you can have a car, you can drive it for 1,000 years, 100 years. Cumulative trauma is what makes people die before they become 2,000 years old. Every day you have cumulative trauma, you have to go to sleep to recover. At a certain age, you lose the joints that you use them a lot. Cumulative trauma is called repetitive stress. That each trauma by itself does not cause an accident, an injury. Repetitive stress will cause injury at work. That is a very fundamental concept in industrial safety and health, and fundamental concept in physiology and pathology, fundamental concept in wear and tear. Cumulative trauma, man, come on. Number 2, arthritis was a pre-existing condition for decades. That's what he said. Arthritis was pre-existing for decades. Well, how did he know that? No injury was found despite the medical diagnosis of traumatic collapse. So that is a bizarre. He said there is no injury, but the diagnosis by the doctor said traumatic collapse of hand bones with angulated scaphoid. And then 3 doctors, not one, 3 doctors put me on restricted duty, which means I cannot use him because each hand is inflamed. But he said there is no trauma. Well, because why there is no trauma? Because he does not believe in cumulative trauma. If he does not believe in cumulative trauma, how is he going to stand any legal challenge? Once you mention legal challenge, the insurance companies leave you alone. Petitioner number D or 3. Petitioner was outstanding 72-year-old man. How did you know this person is out? Some people drive trucks at the age of 90. That is subjective and unsubstantiated. Because how did you know the person is outstanding? There was no injury in the hand before. Number E. Work did not cause injury. That's what he said. Work did not cause injury, despite not knowing what facts took place at work. He did not see the videos or the condition of the work. He doesn't know even what kind of work we do, but he said work did not cause injury. Yeah, well, how about what kind of work is it that does not cause injury? That is the only work that can cause injury. That is why he tell you, if you are injured, Walmart cannot accommodate injured truck drivers because it's a dangerous job. It is a cumulative trauma job. The most traumatic job. It does not cause injury. Number F. Degenerative changes existed for decades. Oh, come on. If you say degenerative, what makes the changes are degenerative? Said no, degenerative have to have reason to make the degeneration does not just happen by genetics. Things degenerate because you use them a lot. You use them a lot because you work you have a different job. It's called truck driving. It is called a job that is not everybody can do it. Degenerative change existed for decades. He cannot prove that decades. He can prove it that the degenerative changes. He cannot even prove it at all because there is no injury before. With disregard to the traumatic nature of trucking, degenerative changes existed for decades with disregard to the traumatic nature of trucking. How did he know that? That caused degeneration. Somehow he thinks that for decades there was degeneration. Then he contradicted this with disregard to the traumatic nature of trucking that caused degeneration. He already believed that trucking caused degeneration. Of course, one expects that an insurance company would always lean to self-serving biased opinion. Of course, you get somebody to pay money to lie, to deny pay. That is where courts and lawyers are made for. That is just an angry statement, I know that. Number 4, an independent medical examiner is a must and would be challenged in the work-come hearing. You have to have an independent medical exam to present your facts. Now we are back. This is the second trick she is pulling now. I urge you to facilitate, not impede, my work-come claim in order to reduce litigation and suffering. Thank you. This is another response from me. I think in the same day. I am dismayed by your futile effort to impede the process of work compensation, not work compensation, by resorting to peer review. This was another angry email. By resorting to peer review when nobody requested one. The initial request was for independent medical examiner, not peer review. Unfortunately, you either ignored or dismissed the above sloppiness of Dr. David Rink. She is going to respond by saying she is not a doctor, of course, but she knows how to. I don't think she's a bad person, she's just somebody is pushing her. Who does not believe, I put that in the parentheses, who does not believe in cumulative trauma. Every court in the land and every medical authority recognizes repetitive stress as a cause of cumulative injury, except your preferred reviewer, Dr. David Ring. I put 5 exclamation mark on Dr. River. So everybody believes in cumulative trauma as a cause of injury, but our fraudulent Dr. David Ring does not believe in cumulative trauma. Now she responded back, of course I keep bashing that woman, to me. Understand, I am not a medical professional, and this was the reason your claim was referred to nurse case. Now she's blaming the nurse case. The nurse case screwed her up. Well, everybody have to blame somebody else. Management, to assist with your medical care, you are mistaken. The medical director requested a peer review once your medical records were received. Well, the medical records are received, but they are not everything. So she says the medical director requested a peer review once your medical records were received. She requested a peer review, but she cannot use it. She can use that for her own satisfaction or for her own for self-deception. The guy who bought the review is an idiot. The Dr. David Ring is just an idiot. He's scamming them. Was received by Dr. Ramesh stating that your injury is related to arthritis. So somehow she thinks that Dr. Ramesh decided that the injury is related to arthritis. So what causes arthritis? Degenerative. What causes the degeneration? Well, Dr. Ramesh did not know how many years the process started. A peer review was requested to receive a second medical opinion other than Dr. Ramesh. I understand you may be frustrated with by what Walmart Claim Center is not impeding the process, the process of your worker compensation claim. There is a process. Somehow she wants to tell me she wants a second opinion. She got a second opinion, a lousy second opinion. She already got a lousy first opinion. Dr. Ramesh says there was an arthritis. What causes arthritis? He did not want to get into that. He said it was there before. It was not industrial. Well, how do you know that? It's not his job. But he requested an independent medical review. There is a process with any insurance company. No, there is not. Of what is accepted under claim. If there was a process, why would you deny the benefits in the first place and then you come back and change your mind? I will contact nurse case management for an independent medical exam. Now she's going to go back to do the right thing. To be scheduled. Once scheduled, I will forward you the appointment information. Please ensure that you provide the attorney if you retain the legal counsel. And here is Mr. God. Now we're going to our lousy criminal doctor. We are now having titles. The University of Texas at Austin. Bill Medical School. Here is the doctor, David Ring, medical doctor and PhD, doctor of philosophy, associate dean of comprehensive care. Remember, dean means administrative job. Co-director. He's going to put all these titles to scam everybody. This son of a bitch. David Ring, Austin, associate dean for comprehensive care. What's comprehensive care? Administrative job. Co-director, Center for Health Communication. Think tank. He's a think tank, remember that. Professor of Surgery and Pre-Operative Care. How do you become professor of surgery? Okay. Professor by courtesy of psychiatry and behavioral science. Really? Psychiatry and behavioral science. This maniac is going to treat psychiatry and behavioral science. Professor by courtesy of health and social work, the University of Austin of Texas at Austin, DMA. Look at how many titles that guy have. Courtesy, surgery, and he's going to screw up everything. University of Texas. And Walmart can buy this garbage. And here is his phone number, and here is his name. And he's sent a letter to his review, Melissa Tone, MD. That's a doctor, Melissa Tone, medical director of Walmart Group, Texas. That's the date of birth regarding name, date of accident. Dear Dr. Tom, this is a magnificent peer review by Dr. David Ring. On your request, I reviewed the document care of Mr. So-and-so and provide my opinions and suggestions. I reviewed records provided by you from WorkMed. Michael Ramesh, that is a orthopedic surgeon. Reyes, that is the radiologist that did the X-ray on the hand. There were more than one radiologist. What I learned from the record, here is what he learned. Mr. So-and-so is a 71-year-old truck driver, which I must say is quite impressive. Well, you don't do that. Suppose you, okay, quite impressive. He reported new right hand pain at work on that date, November 3rd, 21. The nurse case manager reports on January 28th, 22 has important information from Mr. So-and-so. This is information that I provided to the nurse management. For 8 months prior to November, prior to November, I had repetitive motions of cranking the trailer. Of course, you don't have 8 months. You have 7 years. 2.5 was warmer. You crank a 25-pound crank. No, you crank 25 times. You crank a 25-pound crank. No, there is no such thing. 25-pound crank. You crank 25 times. If the trailer is too old or heavy or has rust, it makes it more difficult to crank, and it makes your hand awkward. Of course, when you crank a heavy trailer or a rusted trailer. I have done this for years. So now we've done it for years, not for 8 months. But with Walmart trucking, you deliver to stores, so you can take 1 trailer or 8 trailers in a day, depending on your route, which is an increase in the activity. On November 3rd, 21, there was a bone was bulging from my hand between the thumb and the wrist, and it was painful. It became difficult for me to grasp anything with my hand using my thumb. I could not hold the steering wheel with my right hand. In January 22nd, I thought I had cancer because the area was shiny and bulging, and by that point I could not move my thumb at all without extreme pain. On January 28th, I started looking for a place to go to. Well, it was not January 28th, it was January 19th. On January 28th, I started looking for a place to go to see. I went to an emergency center at Instacare, and they thought it may be a cyst, and then they told me I needed to see WorkMed. Then I went to be seen by WorkMed, and an X-ray was done that showed severe angulation of the bone, and I was diagnosed with ligament rupture and referred to an MRI. Mr. So-and-so was evaluated at Intermountain WorkMed by Leslie Rasner, MED, on January 19th. For this visit, the description is that the crank missed or jammed. The symptoms are worse at work. There is also numbness of the first 3 fingers. The note says, patient does not feel safe operating commercial truck at this time. Exam notable for prominence, described as a swelling at the base of the thumb, metacarpal and trapezium trapezoid, tender over the first dorsal compartment. MB stable, MB medical, metacarpal, MB stable. I leave MB for now. Normal strength and sensation. Wrist motion is not mentioned. Radiographs show old. No, it did not say old, it say traumatic. There is no old, the doctor ring. Scapuloleonate ligament insufficiency. It did not say even insufficiency, it said traumatic collapse, which with wrist arthritis, scapuloleonate advanced collapse. With wrist scapuloleonate advanced collapse. Advanced means old, and trapezo metacarpal arthritis. Referred to orthopedic hand surgery consultation. Return on the 26th, no change in symptoms or exam. That is return to WorkMed. On February 2nd, he saw Dr. Ramesh, an orthopedic surgeon. He confirms the diagnosis. Which diagnosis? The collapse, the scapulohumerate advanced collapse. Confirms the diagnosis and focuses on the wrist. Flexion is 40, extension 50, positive grind at trapezo-metacarpal joint. Dr. Ramesh refers to the problem as acute or chronic. Whether acute or chronic, this is a histological process. He cannot take a biopsy to find whether it's acute or chronic, which is confusing orthopedic jargon. Now, Dr. Ring wants to say that was a jargon, which is confusing. That might suggest new pathology. You already have a collapse. That's advanced collapse. He said the advanced collapse is not a new pathology. He clarifies by stating clearly that there is no new pathology, only new symptoms. Well, how do you get new symptoms if you don't have new pathology? And those symptoms are not causality, which means what? The symptoms are not caused by something or the cause is not by the symptoms. A cortisone injection was performed, surgical opinions are discussed, and independent medical examiner was requested. Well, if the Dr. Ramesh was determined, why would he request for an independent medical examiner? He requested an independent medical examiner to find out what causes what. On February 7th, another MRI on the right, no, this is the first MRI. On February 7th, an MRI of the wrist was performed and it does not provide any new information. Well, we don't even have the MRI final. Okay, suppose the new information is only arthritis. Any new information, the arthritis of the thumb base and the wrist are depicted. So you have information. Let's say there is arthritis of the thumb base and the wrist are depicted. Fine. This is not new information for his opinion. On the same date, an MRI on the left wrist was not on the same date, it was on another date, was interpreted as trapezo. Now this is the other hand now. We are now talking about the other hand. The left wrist was interpreted as trapezo-metacarpal arthritis of the trapezoid and metacarpal joint. Trapezoid arthritis. Ulnar carpal impingement. So there is impingement between the ulna and the carpus. And a radiocarpal arthritis. So there was arthritis and impingement on the left wrist. On the left wrist, there are too many impingements, and arthritis. He wants us to say none of that was new. All that was old. Return to Intermountain on February 22nd. This visit seems related to the left wrist, noting similar symptoms as on the right. The note suggests that Mr. So-and-so, the patient, is under the impression that he has traumatic rupture of one of the ligaments on the right wrist. The traumatic rupture, it was determined by the radiologist, the traumatic collapse. Exams notes mild swelling and decreased motion of the left. So the left was swollen too. Radiographs were interpreted as advanced trapezo-metacarpal arthrosis, referred to orthopedics. So here you have arthritis or arthrosis of the joints. If you have carpal tunnel syndrome at work, because of the repetitive stress, you have an injury at work. But here you have more than that. You have arthritis, and impingement, and collapse. And our peer reviewer, Dr. Ring, thinks all that is nonsense and there is maximal recovery. My thoughts on the records. That is the thoughts of Dr. David Ring. Mr. is a remarkable, he kept repeating, man, still driving a truck at the age of 70. He has degenerative, well, he doesn't know that people drive a truck until the age of 90. He has degenerative changes in both thumbs and both wrists. The findings on the right wrist are of decades-old scapulohumeral injury with consequent arthritis. So in other way, he wants us to say the scapulohumeral injury. So he did believe there is an injury. With the finding on the right wrist are of decades-old scapulohumeral injury with subsequent arthritis. How would you prove that that injury was old? With consequent, so he wants to say the arthritis was due to the old injury. Other arthritis is not, on the other hand, still have arthritis. He has new symptoms from these problems on the right and on the left. They remained well accommodated. Well, in the left they are also problematic. That's why we seek treatment. There is no new pathology, no injury, and this is not appropriate for work claim. So now he wants us to say that he made already a determination that there is no new pathology. You have a collapse and rupture and impingement. He said that is not new, it's old. How old it is, decades. How did he know? He doesn't know. No injury, so he does not know that the traumatic injury of trucking, traumatic cumulative trauma, stress, repeated stress of trucking does not cause injury, which means you came there with arthritis, man, and you have doing the most difficult job and you get injured because you are injured before, you are not injured now, and you are not going to consider that work claim. It's scum, not appropriate for injury. These are degenerative, pre-existing changes. What degenerative means? What means they have a degenerative disease? What causes them to be degenerative? Here he say he's degenerative, and here he say is injury, pre-existing that were until recently were accommodated on the right as well. He drove the truck with these issues. Well, cannot say that these injuries were there, drove the truck with these issues, but now he cannot drive the truck with these issues. He drove a truck with these issues before. Yeah, so he assumed that there is before, and it is as appropriate and safe today as it was then. Well, this guy's an idiot. If you already have new symptoms and you say he drove before when he doesn't know that before, if I have that problem before, and now you have new symptoms, are you saying it is safe to drive today so you never get old? You keep driving with the trauma, with collapsed hand, and it is appropriate and safe to drive a truck today as it was then. So you never get old. You keep driving the damn truck with injury, without injury, and can he have a good finish? Say you have a degenerative injury, and now you have symptoms, you have collapse, you have impingement. Say you cannot drive a truck because I come to you telling you I have a problem. Say no, he can keep driving and it is safe. Well, can you drive a truck on my behalf, for God's? Now he is going to offer great answers to specific questions. The first question he was asked by the doctor: what is your assessment of petitioner's conditions? That is the first question. Please opine as to whether the associate sustained either an accident or cumulative trauma. So in other way, the doctor of Walmart wants to believe in cumulative trauma, but she hired a guy, a medical reviewer, who does not believe in cumulative trauma as it pertains to the 11/30 incident. Is it cumulative trauma or an accident? That is a director wants the medical reviewer. He does not believe in cumulative trauma. Please discuss new reports of left hand and wrist complaint on February 2nd with WorkMed. It is notable that left wrist symptoms started on the same day as the left wrist MRI. He thinks that the left wrist started on the same day when the MRI was taken. Perhaps he found out, he's now speculating, he found out there are degenerative changes on that side after having the comparison MRI and then started to notice symptoms. He think he's now reading my mind that I start noticing symptoms after the MRI. There is no injury on either wrist. That is a great recommendation. He said there are no injury on either wrist. Both wrists have impingement and one of them is collapsed. And both wrists have arthritis. I don't. God bless you, Dr. David Ring. I don't believe in cumulative trauma. Then you need to take a hike. He has arthritis in his thumb, base, and wrist that was until recently well accommodated. So what causes arthritis? He does not believe cumulative trauma. Please review, compare, that is the second question, the bilateral wrist and right hand MRI and determine what is acute versus pre-existing degenerative. She wants him to determine is it acute or it is pre-existing degenerative. If it's pre-existing or degenerative, he wants to say degenerative. If it say degenerative, what causes to be degenerative? I will comment to that. The problem was completely obvious and obviously degenerative based on the radiograph alone. That said, having a comparison is useful for demonstrating what an amazing individual, he is now amazing and outstanding, amazing Mr. So-and-so is. His thumbs and wrists have advanced degeneration that was so well accommodated that he could drive a truck. There is just no understating how impressive that, when you say impressive, you say impressive, amazing, outstanding. This is subjective because what is, he's impressed, he's amazed, he's shocked. That is not factual. Did the petitioner have a pre-existing condition that contributed to any extent to her alleged industrial injury? Yes or no? He said yes, there was a pre-existing condition. What is a pre-existing condition? He said degeneration. He did not go back to read the record or the facts. He doesn't know how things developed, but he was able to look at the images and make up his own mind. Number 4, this is the alleged industrial incident. Medical cause, permanently degenerative, permanent. This is the alleged industrial incident. Well, how did he know the incident if he did not see it? Industrial incident, medical cause, permanently aggravate, temporarily exacerbate, or have no effect on the petitioner condition. In the event of temporary exacerbation, please indicate when she returned to baseline. She means the aggravation, return to the baseline. Here is the great answer. There is no pathology of any sort from any source. So cumulative trauma is not his business, and the tracking is not his business, and he wanted to say just there is nothing wrong, everything is okay, and there is no pathology. Well, but there is no new pathology. How did he know what is all the pathology, what causes it? There is of any source. If you have degenerative degeneration. Would that as accident make it worse? He said, no, there is no new pathology. But there is a pathology. There is a collapse, and there is impingement, and there is a swelling. What period of time is going to determine what period of time, if any? Was the petitioner reasonably required to be off work or limited? Three doctors decided have to be limited, or limited to light duty as a result of the alleged industrial incident. There was never a time that work restriction was needed. Well, the doctors determined it have to be restricted because there was an injury collapse. The problem in his wrist and thumb have been present for decades. How many decades? And how do you prove it? How do you prove they are present for decades? Because he does not believe in cumulative trauma. Has the medical care rendered to date been reasonable and medically necessary on an industrial base? The medical care, yes, with the exception that as soon as the first radiograph, these should have been identified as not related to work and transferred to commercial insurance. How do you have a radiograph that say collapse under arthritis and you say it is not related to work, and when you have a person is at work and get injured or suffered an injury, if the person have a degenerative arthritis and was working in a repetitive work, why would you assume it is not the cause? If you say it was there for decades, how many decades? And what if it was there already? Like everybody has degeneration for decades. Everybody suffered from degeneration. You cannot say that was not aggravated or exacerbated by the repetitive work. The cortisone injection into the wrist is unnecessary and likely not very helpful, but a lot of people offer it. How do you know it is not necessary? It's not important anyway. That is his opinion. He does not believe in cumulative trauma, and he does not believe in cortisone, and he does not believe there is an injury, and he does not believe there is a reason for to take a break, and he does not believe that it is work related. Number 7. Do you recommend any additional treatment? If so, please specify whether the need for additional treatment is related to the alleged industrial incident or some other condition for the incident. Here's the answer. Mr. So-and-so could consider surgery, but it would be outside any work claim. How do you consider injury outside a work claim if you doing a work that causes a problem? Since these problems are complete unrelated to work, well, we have to know the nature of the work to know if it is related or not. I would personally caution Mr. So-and-so to think long and hard about any surgery, given how well he has proved that he can do without it. Well, he can do without it. How do you want me to do it without it if you have impingement and collapse? I do let him think about it for many months and do everything possible to be sure he has a crystal clear understanding about what is going on. If he has any thoughts that he is injured, those need to be reoriented before he decides. What does it mean? I don't know. If he has any thought that he is injured, these need to be oriented before he decides. That has no meaning at all. Number 8. Has the petitioner reached maximal improvement? If so, on what date? If not, when do you anticipate that she will reach maximum medical improvement? That is the director of Walmart. Ask the Dr. David Ring. Is maximal improvement there? He reached maximal medical improvement on the date of initial evaluation on, this is supposed to be January 19. So when I went to the medical evaluation, when I have an injury, I have maximal improvement. That is his opinion. When the degenerative changes were identified, when the degenerative changes were identified and the new pathology was excluded, well, the new pathology, there was a collapse. So it was not excluded. There is a swelling that was not excluded. There is a pathology that there was inflammation. There was no previous pathology before. Did the petitioner have any temporary or permanent restriction? If so, when the restriction was put by the doctor, by 3 doctors, if so, such restriction related to the alleged industrial exposure or pre-existing non-industrial or congenital. So the question was that, are these restrictions related to the industrial exposure, which is cranking, pre-existing, which is arthritis, he did not say where it come from, non-industrial, which doesn't mean if it is pre-existing, or non-industrial, or congenital. There is no injury. There is no injury because he does not believe in cumulative trauma. There is no injury. He has never, and will never. So he can predict the future. He has never and will never have any restriction. So I can work until I become 1,000 years old based on arthritis. If the arthritis is not going to cause me restriction, why does the arthritis cause the collapse or cause me to have surgery? So he can live with the arthritis forever without never have restriction and will never have any restriction. Dr. David Ring, MD, shouldn't that be reported to authority? This guy is a thug. Shouldn't that be reported to the federal government? This guy is scamming the insurance companies.